Hello, and welcome to Williams Mullen's Trending Now, an IP podcast, a legal podcast focused on providing innovative companies and investors with important and timely information concerning intangible assets such as patents, trademarks, copyrights, and trade secrets. I'm your host, Janet Cho, and today I'll be joined by my colleague, Elizabeth Davenport, a paralegal in our intellectual property practice group here at Williams Mullen, to discuss Paralegal Insights, a collaborative trademark practice. Elizabeth, how are you today?
I'm doing good. Thank you, Janet.
Well, I think we've got a really interesting topic today, but before we get started, this is the first of what we hope to be a series in this podcast, and I thought it would be important just to talk about the goals of this podcast. And the first, which I think is ultimately the most important part, is really recognizing and celebrating the paralegal-lawyer relationship. I think a lot of law practices have lawyers and paralegals working together, and I think it's a really unique and important relationship. But certainly in the trademark realm, the paralegal-lawyer relationship is necessary, important, critical. And so it's our goal to recognize this relationship and also to have the paralegal's perspective when it comes to daily trademark practices and best practice tips. We also want to convey really helpful practice points and also encourage learning. We want to learn from you all out there, and hopefully we will share some useful information and have fun along the way. And it's our intention to share this information with anyone who's interested in trademarks or wants to learn more about trademarks. But we're hoping that we provide useful information, especially for those maybe in law firms where there isn't a dedicated intellectual property or trademark practice. So it's not something that comes up every day, or perhaps for those working in-house, again, who maybe don't work in the realm of trademarks every day, but it does come up. So we're hoping that we can provide you with useful information and practice tips. So with that, before we get started with Elizabeth's perspective on the trademark practice, I thought it would be helpful just to share some basic information on what we mean when we're talking about trademarks, because if we're going to have this discussion, I think it's important to start with what do we mean when we talk about trademarks. So a trademark is a designation of source. The way it should work is, as a consumer or as a member of the public, when you see a trademark in the marketplace, be it online or on the shelf of a store, you immediately understand who's providing that particular product or service. The way I like to look at it is a trademark is a mental shortcut, and it cuts through all of the commercial chatter surrounding your consumer engagement, and it allows you to immediately make a connection between the mark and the offer or the origin of that particular product or service. And also there should be a fair amount of goodwill that goes with the trademark, meaning when you see that mark, it's something that gives you good feelings or a desire to purchase that particular product or service. And one thing that I think is a common misunderstanding in terms of trademark rights is how one actually comes to acquire trademark rights. I think a lot of people out there listening may think that trademark registration is the mechanism by which one acquires trademark rights. But at least in the United States, how you acquire rights is through your use of a mark in the marketplace. So once you commence use of your trademark to promote a particular good or service, that's when your rights arise. Now, that said, a trademark registration is helpful. It's a very useful enforcement tool, and it can help you secure a broader and what I would consider a more stable scope of rights. So if you are considering advising a client to, if they're in their process of selecting a mark and the client is a bit on the fence about whether or not they should register, it's something they should seriously consider, especially if it's a mark that they consider important to their business, however they define that, and if it's a mark that they plan on using for the long term. Perhaps if it's something that's more seasonal or there's less of a thought to use it for a sustained period, maybe that's not a mark that you want to register. But certainly for things that you plan on using for the long term or really, really critical marks to a particular client's business, those might be marks that you want to stop and consider filing applications for. And you can file applications at the federal level at the United States Patent and Trademark Office, and you can also file applications in the individual states. The scope of protection is different on those levels. If you are filing or if you're granted registration at the state level, you will be granted exclusive rights in that particular state. If you obtain a federal registration, you will secure exclusive rights in all 50 states. So one thing we wanted to talk about today is before you start using a mark or before you start filing a mark, a question that Elizabeth and I get a lot is there any research I should do? Or I've heard of something called a trademark search. What is that? Do I have to do that? What is this all about? And so that's what we're going to focus on today as a practice point is ultimately, what is a trademark search? What does it comprise? Why might it be helpful to you? What do I need to do? So with that, I'm going to pass it to Elizabeth so she can share all of the useful information you need to know about trademark searches.
Thank you, Janet. Basically, there are two trademark searches, a preliminary search and a full search. In a preliminary search, you can conduct it at the uspto.gov, and there are a variety of ways to conduct the initial search there at the uspto.gov. You can use wildcards, such as using the word "and" in your search in the search field. You can insert a question mark as a suffix for searching, and even use the $sign to replace a letter in the search field. And also another option is online screening, using an online screening database. I like to use Sages. It allows you to conduct knockout searches in the US, state registries, and it also has available foreign trademark registries, a total of about 186 jurisdictions. With the Sages search, you are charged with viewing any hits that you want to look at. I like the Sages searches. I find it a little bit more user-friendly than the searches at the USPTO database. It allows you to search in several different variations, and it has a preview feature which will allow you to actually look at the mark before selecting it, to selecting the hit and being charged for it. Another option is a US full search. Williams Mullen has relationships with certain vendors that offer us discounts, and the time frame for receiving searches is usually about 2 days for a full search, or you can get it next day, same day, or a 4-hour turnaround. In the US full searches, an analyst conducts the search for you for identical marks plus variations on spelling, taking into account phonetics. They search the USPTO, state registries, as well as searching for business names, common law references, and domain names. Once you receive the search results, an attorney will analyze and provide risk analysis based on the search results. The differences between a USPTO online search and a Sages search and a full US search is that full US search is more in depth and is performed by an analyst. It provides other relevant information than just what is on the Trademark Office registry. The cost of preliminary USPTO or Sages online search usually involves the hourly rate of the person conducting the search and analyzing the search results. A full US search includes a vendor service fee and then the hourly rate of the attorney who will analyze the search results. The timeline for these searches, obviously for a USPTO search and a Sages search, the search can be conducted, anytime, immediately upon request. A full US search can be ordered for a turnaround time, like I said previously, of about 4 hours, same day, next day, standard 2-day turnaround. The shorter the turnaround time for a full US search increases the price. The scope covered for a full U.S. search includes the USPTO database, state registries, business names, common law references, and domain names. When you go on the USPTO online to conduct a search, that only covers the USPTO registry. The search results that you receive, at the USPTO will give you an idea of the likelihood of confusion with prior applications or registrations that have the exact or similar mark with similar or related goods or services. Once we have the search results, we can determine the status, the ownership, the filing basis of any prior marks, and then dig a little deeper into maybe the USPTO record to see if there is anything in the public record that might deter or alleviate any concerns. And that, I'll hand it back to you, Janet.
Thank you so much, Elizabeth. As you all could hear from Elizabeth's breakdown of trademark searching it's very important. And I think ultimately we would say it's a really helpful tool to give you a sense of what's out there in the landscape and perhaps share some insights on how protectable your mark may be. So searching is definitely important. And if you have any questions, feel free to, reach out to Elizabeth or myself, or contact the attorneys you may be working with or collaborate with your clients. We certainly don't want to convey that searching is sort of this rigid process. There's a fair amount of flexibility in terms of how it's done and what the focus should be. And we would encourage everyone to make sure that your search meets your timeline needs, your financial needs, and the scope of what you're looking for. So with that will wrap up our discussion on Paralegal Insights, a collaborative trademark practice. I'd like to thank Elizabeth for joining me on Trending Now, an IP podcast. If you have any questions or suggestions for future episodes, please contact us. You can also visit our intellectual property practice page at williamsmullen.com/IP. There you can find out more about our team, as well as past episodes of this podcast and legal alerts. Be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening, and until next time.